Adjournment request, if any, from item number 1 to 6.
In respect of item number 3
Yes.
and item number 7, well, I have a prayer for accommodation today. I pray for taking up the matter on Monday.
3 and 7.
3 and 7.
Have you informed the other side?
Yes, my
My lord, I am for the petition, my lord.
In which item?
Both one, my lord. Item
All right.
3 and 7.
When do you want it?
Well, I on Monday.
Today, the bench will not be available.
My lord, may I pray for it on Wednesday, my lord? Outstation counsel is appearing there.
That's right. So, but the bench would. Next week, this bench is not available.
My lord, urgency is on our part, my lord.
That's right, but
My
the
lord.
bench would not be available. It can only go to 15. 15, 16th, whichever date is suitable.
My lord, two issues are there, my lord. One is pushback and another is, my lord.
That's right. So let us have the date first fixed.
My lord, my lord.
We'll look at the issue thereafter. Now tell us whether 15th or 16th suits you.
My lord, on Wednesday, 16th, it will be better, my lord.
16th is Tuesday.
16.
My lord.
All right. Alag likhna, 3 and 7. A prayer for adjournment has been made on behalf of the state / respondent after obtaining consent of the Direct Counsel for the petition. Let this case be listed
Pushback no kore no.
on 16th
My
of
lord.
September. All.
Oblige.
From item number 8 to 13, adjournment request.
My lord, in item number 9,
Yes.
I'm appearing for the respondent, private respondent, my lord.
Yes.
So let him serve me a copy, my lord, and it may be taken up in the next week.
Let us see. I mean, all right. You want a copy of the brief?
Yes, my lord.
All right. A request has been made, a prayer has been made on behalf of the respondent for being served a copy of the memo of appeal. The land counsel for the appellant submits that it shall be done during the course of the day. Let this matter come up for consideration on 15th of September.
Oblige, my lord.
This was item number 9.
May I please, Lordship? Lordship, it's in prayer for listing with PIL for admission. The subject matter of the PIL is that the government of Assam is going to conduct a socio-economic survey to identify 5 subgroup of Muslim communities, indigenous Muslim, excluding the Muslim of Borak Valley. So I have challenged the decision of the government. So it is last posted on 17/3, Lordship. Therefore, it has never been listed.
All right, 22nd of September.
May I please, your
22nd of
lordship?
September, give this.
Lordship.
My lord, I
May I
pray,
please, your lordship?
my lord, I pray for listing of a bail appeal, my lord, in condonation appeal. Filed by the state, my lord, I am the opposite party. The learned citizens are directed to pay for salary and pension. Against that order, the state has filed an appeal that has not been listed. Next week, any date, my lord.
16th of September.
May I please, your lordship? May I please, your lordship?
Yes.
My lord, I beg to make a mention for a listing of a review petition. Matter pertains to your lordship who has taken up the matter that regarding the district and session judge who has been put under suspension and subsequently given compulsory retirement. The Nagaland matter. Your lordship has fixed that matter on 22. Now what happened is that after I was given compulsory, I have filed a review petition against one order passed by this bench, which was been challenged in the Supreme Court. And the Honorable Supreme Court said that, okay, you can file a review. So kindly post up the matter today, because tomorrow they are going to conduct a departmental inquiry.
No, today it is not possible. It can be listed only on Monday.
Monday,
Only
my
on
lord.
Monday.
But your lordship is not sitting with the bench, your lordship.
So the review is of our judgment.
Yes, your lordship.
Then it goes on 15th.
15. My lord, can I take the leave of this court to apprise the authority that it is put under challenge? Because if I appear, they may frame the charges against.
That's your choice. I mean, you can say that.
My lord,
We are not saying anything. You have filed a petition. We have allowed it.
my lord.
All.
Oblige, your lordship.
Don't unnecessarily tell the authorities that we have given you the liberty.
No. But I will apprise the authority. My lord. Oblige.
May I please your lordship? Sir, beg to mention the listing of fresh writ petition. It is directed against the order of the CAT, wherein it refused to grant us an interim relief on the ground that no division bench was sitting, your lordship. There is some urgency in the sense that I was not selected for the viva voce examination.
17th of September.
Your lordship, it is next fixed up before the CAT on 15th. The urgency is that the viva voce will be conducted today itself.
All right, 15th.
Before 15th, if it is
Before 15th, it's not possible. How many times would the bar require this information from the bench?
obliged.
15 September. Daily list, any?
May I please, your lordship?
Yes.
I beg to mention item number 15, your lordship.
One
Yes.
file.
The respondent sent was supposed to file an affidavit, your lordship. And they just informed me they have filed their affidavit yesterday, your lordship. That copy has not been furnished to me, your lordship.
Serve a copy on the petition.
Next week, your lordship, kindly.
So we only pass it over. It will be listed on Monday.
Any other request? Daily list for this item 1.
May it please this moment. There's an interlocutory application praying for condonation of delay, my lords.
Of how many days?
1224, my lords. However, my lords, 923 days were spent pursuing the review petition, my lord.
That is that.
So
Anyway,
section.
let it be contested. Have they filed the affidavit?
I've been told, my lords, they filed the objection yesterday. I have not received a copy.
Yesterday only.
Yes.
So. Take time. Okay. This court has been informed that the affidavit in opposition on behalf of the state has been filed.
On behalf of the
yesterday.
state, respondent number 1, private respondent.
On behalf of respondent number 1 has been filed only yesterday. Let this matter come up for consideration on 17th.
17. Deeply obliged, my lord.
Item number 2.
Your Honor, we have preferred the review on 27/8, my lord.
Six eight. Yes. The order dated 6/8.
Yes, my lord. We preferred the
Yes,
review on
what has happened to the review petition?
we have preferred on 27/8, my lord. I'm expecting to list it by next week, my lord. I'll make a mention.
You make a mention, have it listed, have it decided, otherwise you're in contempt.
Yes, my lord. That I understand.
You're clearly in contempt.
Yes, my lord.
Here. Mr. Katanier, learned advocate for response number 1 and 2, has informed this court that a review petition against the judgment in question has been filed on
27/8.
on 27/8/2025. And the same is likely to be listed in the next week. List this matter on 14th of October.
Obliged.
Obliged.
Item 4. Make visible.
Yes.
But in this case, notice was issued for lesson number 1 and 2. The name is not shown, Mr.
Or the
Gogoi
post of vice principal.
Yes, my lord. There are two
Correct.
part, yes, my lord. 2 part in the judgment. And 1 part has been after issuing notice, 1 part is complied with. my lord.
Is the report? There is no report regarding service of notice.
We have served, my lord.
You have
On-
served Dusty.
No, not Dusty, my lord. It is we have served it to upon Mr. B. Gogoi, lordship directed.
They're the answering respondents, no?
1 and 2, lordship directed to serve copy upon Mr. Gogoi.
Where is Mr. Gogoi?
But his name is not shown in the cause list, perhaps.
Yes. The lead counsel for the petitioner is present. There is no appearance on behalf of respondent number 1 and 2. Perhaps for the reason that the name of Mr. Gogoi does not appear in the cause list. Let the name of the learned counsel for the respondents number 1 and 2 be printed in the cause list henceforth. List this matter on. We'll have this matter further. 22nd of September. I'll
Much
look up the date if the calendar is free. Now I'm giving the date myself. No, I shall not be giving it now. Yes.
much.
Item number 5.
I mean. 444,
445 days, madam.
You are appearing. Yes, what do you have to say?
Madam, 444 days. And the explanation in paragraph 7, just lordship have a look once and pass any order. I leave to your lordship.
Paragraph 7.
Yes, page 11. And I leave to your lordship.
The judgment in question was passed when?
34-24.
34.
Yes. Paragraph 7.
And no explanation. When
That's
did
all.
you file the certified copy for the order?
That's
When
all.
was that requisition filed? When was it obtained? What is the reason for delay of senior standing counsel for the department? 445 days like this. And what is the judgment?
Judgment at my lord, page number 208, my lord.
In this petition itself, page 20.
In fact, in IA also, my lord, it is
page 20.
annex, my lord.
In this petition, I page 20.
What had happened? What had happened in this case? Let me the merits and then only we will decide.
Yes,
If
ma'am.
it is not, if the appeal is not worth entertaining, we will not
Yes, ma'am.
entertain your petition
The
application.
petitioners were my lord, initially appointed as my lord, stipendiary teachers, my lord. And the
Stipendary teachers,
Stipendiary teachers,
they'll get stipend,
stipend, my lord. And
Okay.
subject to completion of junior basic training, they will get the regular scale of pay.
right?
So they were appointed in the year 1991, my lord.
Hmm.
Thereafter, according to them, my lord, they have been deputed to junior basic training in the year 2003 for 8 months. So subsequently, my lord, they have been released from the junior basic training course, my lord, and
So
they have
what happened thereafter?
they have resumed their duty, my lord.
Hmm.
Thereafter, my lord, from 2003, from 2007, their salaries were discontinued, my lord. Subsequently,
On what ground?
on the ground that their initial appointment was illegal. So, my lord, in Assam, from 1991 to 2001, there are lots of irregular and illegal appointments. So we have the government have constituted a committee, screening committee, to decide their appointment, my lord. Accordingly, they have submitted their applications, my lord, and they have participated in the screening process. In the screening process, my lord, it has been found that, my lord, their initial appointment was irregular, but they have continued in service. So accordingly, a cabinet decision was taken that subject to their qualification, they will be accommodated as tutor or teacher.
Hmm.
So since the petitioners, they have completed their junior basics training, so they have been accommodated teachers.
And now what is,
In 2021, they have been accommodated teacher, my lord.
right?
Subsequently, it was found that, my lord, their junior basic training certificate was fake. So, my lord,
And what is the ground for the learned single judge to have allowed their prayer?
yes, my lord. Paragraph 34, my lord. Page 34. It is said that after the release order and the provisional pass certificate were received from the petitioners in the inquiry, and that was directed to be held.
Paragraph?
Paragraph 34, page 34.
Yes.
It is seen that after the release orders and the provisional pass certificates were received from the petitioners in the inquiry that was directed to be held in the matter by the jurisdictional district elementary education officer, the same was forwarded to the director of SCRT Assam for causing an inquiry. The director of SCRT Assam in his communication dated so and so had informed the director of elementary education Assam that there was no record pertaining to passing of the 8 months primary training course during the period from May 2003 to December 2003 by the petitioner's getting. A perusal of the above noted communication dated so and so would bring to the forefront that it was contended therein that the records pertaining to the passing of 8 months.
So if the records are not available, prima facie that they were not there. And what was their response before the committee? What was their response? before-
During the inquiry, they have produced there only the provisional pass certificate.
Ultimately, it was found that it was fake.
Yes, my lord.
Now, let us see where is the last concluding
Yes, my lord.
ground by the London single judge.
Yes, my lord. Paragraph 39 and 40, my lord.
Not that they were not there, the records were not available. Records could be, non-availability of records could be attributed to many factors,
Yes, my lord.
but then it's required to be heard. What do you have to say?
I leave to lord.
Would you find?
At the very
any-
beginning, I see it, my lord. In the very beginning, I see it, my lord. I leave to lordship, that's why.
Take. We have heard so and so, we have heard Mr. N.J. Khataniya for the applicant and Mr. M. Nath, learned senior advocate, assisted by Mr. D.P. Bora for the respondents. There's an application seeking delay of, seeking condemnation of delay of so many days. We have gone through the application and have found that good grounds have been made out for condoning the delay. Delay condoned, the application stands allowed. The registry is ready to process and list the appeal. List this appeal. We don't fix a date, the registry will do it.
Right.
Obliged.
Your lordship will find during the course of hearing, the principal of the college where we have undergone training, that principal wrote a letter to them. There's a clash between two faculties.
Right. So therefore, perhaps, but the judgment is not very clear. It only says that since the decision was based on a finding that there are no records, therefore it is presumed that the certificate is fake.
Because
There could be some substance in it, but can that be the ground that we'll have to see?
Yeah, my
Therefore,
lord.
the appeal is necessary.
Yes. Of it, on merit, my lord.
Obliged.
Obliged, my lord.
Item number 6.
He wants to withdraw. Probably.
Please, your lordship.
So he's Mr. Aidas. You are Mr. Aidas.
D. Gogoi, lordship.
Mr. D. Gogoi. Mr. D. Gogoi, learned advocate for the applicant, seeks permission to withdraw the writ petition C number 2886 of 2025. Dismissed as withdrawn. The writ petition number so and so is dismissed as withdrawn. The IE stands disposed of.
Keep your lordship.
For admission, item 8.
Yes.
So with limited grants, the appellant is before your lordship. But so while the appellant lordship completed his matriculation in the year 1985, he noticed that his date of birth is wrongly recorded in the admit card. So immediately thereafter, in the year 1986 and 87, he approached the board as well as the school authority. But till 2023, they have not taken any initiation lordship regarding my correction of a date of birth.
But tell me one thing. What is the date of birth recorded in the certificate wrongly?
This was recorded as 25th of February 1966. But according to me, this should be 25th of February 1970.
So you passed your matriculation in which year?
1985. And while I completed
1985. Now, you would have been, by going by the age of 1966, you would have been how many years old at the time when you passed?
19 years, lordship.
19 years.
19
So
years
some
plus.
Four years more.
But
So
it-
what document have you suggested?
Lordship, the document lordship will find at page 43 and 53. Because according to the syllabus rule lordship, within the 3 years, the person concerned has to approach the authority for correction of date of birth.
Yes.
Lordship, may kindly see page 43. This was my first application when I noticed that my date of birth is wrongly recorded in my admit card. Page 43 is the type copy. This was done on 24th of June, 1986, before the secretary.
Now, this was never responded to.
Yes, now,
Where were you waiting for all this while?
then in 2018 and 19, I again approached the authority And they have said that at my application is now cannot consider because of.
That's right. So you file an application for correction on 24/6/1986.
Lordship.
Correct?
Yes,
So
Lord.
you never pursued that. Did you pursue that application?
Admittedly not, Lord.
Admittedly, no.
Not. Then I
Now,
again,
today you'd be around 47 years of age.
now I am Lordship, in the month of February, I am going to retire.
So at the fag end,
Now, Lordship, kindly see the consideration made by the authority. Lordship, if the authorities had they consider my application in the year 1986 or 87,
that's right, but the law only comes to the help of those who are conscious about their rights. Now, you couldn't have sat through the entire, decade for the authorities to make necessary correction, and that also the examination board, which is more often than not very lethargic. So if you sit tight over the matter and only when you pursue it only when you're about to retire.
no, in 2018, in 2017, 18 and 19, I again came.
This is 7 years before, 4 years before.
Yes, Lordship.
What has the learned single just said?
Lordship, that will Lordship find at
Without
page,
going into the merits
yes.
of your claim, let's see what the single judge has said.
Lordship, the page 111, paragraph number 6, they're saying that there is no such record that they have received such application, but there is a seal and signature is there.
Yeah.
Page 111, paragraph 6, contention of the board, Lordship. May I read, Lordship?
1 second, let me first have.
Lodge.
Page 43. Where is the seal and signature? Office seal is there.
Yes, seal and
Correct? Which paragraph are you referring to? That is for your application being time barred. That's one thing.
to Lord.
Now, let us see the proof of your age.
Lordship, kindly see in the original copy, Lordship, page 44, here is a seal of the office, page 44.
That we have understood.
Lord.
The delay aspect we may consider, but let's see what is the proof of the fact that you were born in 1970 and not 66.
I have, Lordship, then thereafter I approached the health services also, relied on these documents. And
Which
the ultimate,
document?
the Lordship, the pass certificate as well as the application filed before the authority and the certificate issued by the doctor. What is it? No. The
Certificate issued by the
the
doctor?
doctor certificate, Lordship.
See, we would have taken your plea more in your favor. We would have considered it, but for the fact that you're about to retire. And law says that this cannot be done at the fag end of somebody's career. Unless there are very strong determinate proof.
Proof,
Let's see
Lordship,
what
the
are the
page,
documents that you placed.
page 45. This is the doctor certificate, Lordship. The original certificate, page 45, original is at page 46. This was, of course, of 1971. As well as the ward commissioner, Lordship, he also given certificate.
Please to certify that so he was born on.
Under his guidance or
This was obtained when,
1971.
and so he knew about this certificate appears to be
Yes.
absolutely.
And according to here,
Absolutely a procured certificate. Now, were you named Mr. Indrajit Dhar? Barely 6 months later than your birth. This appears to have been procured.
the doctor, Lordship, prescription is also there. Page 48, original one. 1970. In the railway hospital, he is a doctor of railway hospital, Lordship. I was born there. My father worked as a service employee of that department,
And
Lordship.
then which other document?
Page 48,
What is that?
this is the prescription of the doctor, Lordship. Yes. Then page 50 also, the ward commissioner, Lordship, of my locality. And most interestingly, Lordship, my elder brother, he was born in the year 1969. To that effect, Lordship, I've given the transfer certificate of my elder brother, page 58. He was born on 25th of April, 1969. The birth certificate. Birth certificate. What is it?
No, why, I mean, if your date of birth, this is in high school certificate, wrong entry. But in Bongaigaon Railway LP School, where you took admission,
Yes.
you had declared your date of birth as 25/2/1966.
Lordship, at that, when I got admission, I am not aware what was my date of birth. It is my father. So wrongly they have recorded. So that is why also immediately in 1985, when I came to know that my date of birth is wrongly recorded in my admit card, so I approached the authority. Within the time frame, Lordship, I have filed application and to support
That appears to be doubtful.
to
For the reason that those two persons who are said to have given you the certificate that you had filed such application, they were never in the service of the board.
No, that is their contention. Now there is a
Sir, this is an oath against an oath.
the
And you
seal.
want that benefit.
So they have not denied the seal.
It is your father's signature.
That decision is taken in the year 2020. Lordship, kindly consider, had they considered my application at a relevant point of time, the things will be different. But after Lordship, in the earlier round of litigation, while this honorable court directed to consider,
Your father did not know that you would otherwise, by stating the correct date of birth, you would retire.
before that, my father expired, Lordship.
Huh?
Lordship, my father expired long back.
That's true. But then this is the entry in the full living certificate. of
Lordship, for a
certification.
moment, kindly see the page 58. This was the transfer certificate given by that school authority itself, that my elder brother,
Where have you spoken about your elder brother having been born in 1969?
page 58.
No. Where has it been discussed by the judge?
That was Lordship not discussed.
You had brought this to the notice of the land single judge.
And at that time, also council was different. I was not.
You can check it up from the pleadings, no?
In the pleading, Lordship, there is no such thing.
How do we take it into account?
No.
How do we take it into account?
In the writ petition, Lordship, of course, I have enclosed that document, but that was not taken into consideration. I don't know, Lordship, while it was argued. Lordship.
But have you made your statement?
In the assessment, in the writ petition, Lordship, I have enclosed.
No, have you made that statement? And closure is all right.
But
Whether you have stated on oath that your brother is born in 1969.
from judgment, Lordship, it is not clear, Lordship.
And even then,
Right.
it is not proved that you were born only a year later. Which month? What is his date of birth?
25th of April, 1969.
25th of April.
Yes, Lordship.
You claim that you were born on 25/2/60, 25/2/70.
But that the certificate of my elder brother is a part of the record in the writ proceeding, Lordship.
What does it prove?
That is,
The age gap would be around 11 months. That's right. The gestation period for a child is 9 months in the womb. This can only persuade us to rethink, but I don't think.
and to that effect, I have Lordship given the affidavit sworn before the judicial magistrate also. That was also enclosed, Lordship. But these things were not considered. My respectful submission is that
Had the authority considered these my applications as well as the documents relied upon by the appellant, the things would different, Lordship. That in the fact and in the year 2023, now suddenly the authority came up where I approached in 2019-18 that those documents were not received by the authority, Lordship. But in the document itself, there is a seal and signature, Lordship. Now they have denied it. I am, Lordship, helpless, Lordship, now right now. The documents of 1986 and 87.
So this was on 25/2/1966. You had taken with your date of birth as 25/2/1966, you had taken admission in class 5.
No, from class 3, at that relevant point of time, Lordship, there was no class 4. Once the one student passed the class 3 examination, he directly promoted to class 5 in 1970, Lordship.
But he would only be 6 years of age. In class 5, that was. But in class 5, this was a certificate. In class 5, you were how many years old? 5 years, 6 years.
While I passed, Lordship, the class 3 examination, 6 years plus, Lordship.
Class 3.
It is not studying, Lordship, it was promoted. Lordship, I have the document to that effect, document is enclosed. The affidavit filed by the school authority, that Lordship will find at page.
The
84.
The appellant has questioned the judgment dated 24/7/2025, passed by a learned single judge of this court in so-and-so, whereby his claim for correction in his date of birth from 25/2/1966 to 25/2/1970 has been rejected. It appears that in the HSLC admit card and certificate of 1985, the date of birth of the appellant has been entered as 25/2/1966. The appellant claims that he was born on 25/2/1970. No sooner the appellant had realized that there was a wrong entry in the academic record of the high school, academic record of the high school, he made an application before the board sometimes in 86 and later in 87 with respect to rectification of the date of birth.
Additional affidavit, yes. No.
The appellant seems to have waited for long when he again made some efforts to have it corrected in the year 2018. Before 2018, but his efforts came a proper. Just of later, the appellant approached this court by WPC number 9132 of 2019, in which there was a direction by this court to the board to revisit the decision regarding rectifying the date of birth of the appellant. However, from the records, it appears that despite the date fixed for hearing the parties or enabling the appellant to produce his documents in support of his contention, the appellant had not appeared.
Subsequently, I appeared, Lord.
he appeared before the board only subsequently. The school admission register also could not be produced by him. School, as a leader. The principal of Bongaigaon Railway Higher Secondary School, Bongaigaon, was thereafter requested to produce the school admission register, in which the date of birth of the appellant has been shown as 25/2/1966, which is the date of birth recorded in HSLC admit card and certificate of 1985. The school register demonstrated that the admission form was filled by the father of the appellant, who has left the world of living a long time ago. In support of the contention regarding regarding the date of birth of the appellant to be 25/2/1917, the appellant had produced before the authorities a certificate of the doctor who was present at the time of the birth of the appellant, and a prescription suggesting medicines for cough and cold to the newborn. However, the claim of the appellant that he had made necessary application for correction in his date of birth in 86 and 87 were not found to be factually correct, as the acknowledgement of such application by two of the employees, by two of the so-called employees of the board, what have I said? Were not found to be in service of the board ever. As such, the prayer of the appellant was rejected. Challenging such order of rejection of such request of change in the date of birth, the appellant preferred writ petition, preferred WPC 4766 of 2023, which too has been dismissed as the appeal. The learned single judge, it has been argued, has relied only on the certificate, only on the admission register of Bongaigaon School, where the date of birth of the appellant was recorded as 25/2/1966. The land counsel for the appellant has submitted that his elder brother was born in the year 1969, and that which fact was never taken into account by the learned single judge, and that the assessment of the court, the assessment of the learned single judge, that if the date of birth of the appellant were to be 25/2/1970, then he would only have been 6 years of age in standard 5, is not correct. The learned counsel for the appellant has submitted that he had studied in that school till standard 3, whereafter he was promoted to standard 5. So at the time when he was in standard 5, his age would be around 9 to 10 years. 9 to 10 years. The law with respect to change in the date of birth is well settled. So, a request cannot be entertained at the fag end of a person's career. The times without number, the courts have discouraged belated claims. The claim could be entertained only on conclusive proof produced by the person concerned, and that also within time. In this exercise, the burden of proof would always lie on the person seeking the correction in the date of birth. Unless there is a strict proof in support of the claim, which is brought to the notice of the authorities within time and not at the fag end of a person's career, no equitable relief could be granted. However, after having said that, we find that two aspects of the matter were not taken into account by the learned single judge. Namely, that the elder brother of the appellant was born in 1969, and that going by the suggested correct date of birth, the appellant would have had been 9 to 10 years of age in class 5, which does not appear to be improbable. In any view of the matter, was improbable. The learned single judge, it has been argued, has also relied upon the statement of the board that the applications preferred by the appellant for correction in the date of birth in 1986 and 1987 were purportedly received by two of the employees who were ultimately found to have never been in service of the board. This statement is prone to further verification, is prone to a requirement of further verification. In any view of the matter, we would care for the response of respondent number 1. Respondent number 1, respondent number 1, 2, and 3. Response number 1 to 4. 1 to 4. Who is the Mr. Katniat is the lawyer? No. Who is the
This should be allowed. This is should. Earlier he appeared.
No, is he still retained as
Yes,
standing
yes.
counsel?
Yes, sir.
Okay. Notice any junior of his.
Morning also I have seen nothing. I will inform him, Lord.
Let notice be issued.
Yes, Lord.
To response number 1 to 4 on steps being taken by the appellant within a period of 2 weeks, both modes returnable on responsibility. We are only 25% inclined to entertain this appeal, but 75% your claim is bogus.
Yes, deeply obliged.
Because these were not considered by the learned single judge, therefore we have issued notice.
Lord.
All right.
Deeply obliged.
2017.
It's precisely for this reason that we have recorded our idea of the law with respect to change in date of birth.
Deeply obliged.
Item number 10.
Yes,
May it please your Lord.
yes.
My lord, I have challenged the validity of the part by the appellate tribunal, my lord, whereby the appellate tribunal directed me to pay 35% of
The requirement is 50%,
50.
reducible up to
Totally,
25%.
yes. 25%, it can be reduced up to 25%.
So can
But
the
in
courts, can the courts enter into that jurisdiction where the assessment of the appellate tribunal is that 35%?
My lord, what has happened in this particular case, I filed the sufficiency application under section 70 of the act. That during the pendency of that application, I filed an introductory application for sending the sale deed for scientific examination. My that application was rejected. Against that application, I went to the appellate tribunal, my lord.
You went to DRT for what?
For Sarfashi Act, my lord, for taking, because they issued the notice.
And you
possession
went for
notice.
what? Interlocutory application was for what?
No, during the pendency, I filed the interlocutory application for sending the sale deed for scientific examination. And that application was
So
rejected.
those sale deeds were mortgaged.
Yes, that was the thing. And that.
So for scientific examination with respect to what? What was your claim?
Because the original was with me, the bank claimed that the original is with them. That was the question to be determined by scientific investigation.
And it would have led to what purpose?
It was for the purpose whether I mortgage the property or not.
Did you claim that you never mortgaged the property?
Yes.
How
That
did
I
you get the loan?
without mortgaging, they gave the loan, my lord. That is the thing. Now, during the pendency, my lord, I filed the application for scientific examination. And that application was rejected. And under that application, I went to appellate tribunal, my lord.
Where have you demonstrated the hardship for us to interfere and make it closer to 25? So from 35, it can at best be brought to 25%. Correct, Mr.
My lord, in view of the judgment of the Supreme Court, my lord, in such cases, that judgment I annexed at page 94, my lord.
Page 94, what is that
Yes.
judgment? Normally, courts are loath to get into this aspect of the matter, but
94, my lord. There are 4, my lord, first of all.
page kitna hai? 94.
After
Why was the bank so indulgent to you?
Pardon again?
Why was the bank so indulgent to you without any encumbrance on any property, without mortgaging your property?
Yes, my that
Loan
has been
of,
done in the state,
crores.
my lord.
1 crore 46 lakh 76,000 was.
Yes, that is there, my lord, but the
Is that
bank has done
possible?
it. Bank has done it. The original is with me, my lord. Even though I am ready to produce the original before this honorable court, my lord.
Yeah. The petitioner is aggrieved by the order dated 7/8/2025, passed by the PRAT, Kolkata, in IA number 430 of 2025, arising out of miscellaneous appeal number 743 of 2025, whereby the petitioner has been asked to make a pre-deposit of 35% of the amount in question within a period of 4 weeks as a condition for entertaining the appeal. The contention of the petitioner is that while responding to the objection filed by the petitioner, the respondent bank claimed that there was creation of equitable mortgage by the petitioner by depositing his original sale deed along with necessary documents. But the fact remains that the petitioner is in possession of the original sale deed. The petitioner contends that he was granted the loan of rupees 1 crore 46 lakh 76,000 as a term loan to be repaid in equal monthly installments of rupees 1,66,807. There was nothing indicated in the arrangement letter regarding creation of an equitable mortgage of any particular immovable property. The objections of the petitioner were rejected by the respondent bank, and the challenge to it before the debt recovery tribunal also could not be sustained. It was under this circumstance that an appeal was sought to be filed before DRAT, wherein the petitioner was asked to deposit 35% of the amount due. amount due. Section 18 of the SARFAESI Act 2002 provides that an appeal against the order passed by the DRT could be filed before the appellate tribunal within 30 days from the date of receipt of the order of the debts recovery tribunal. But on the deposit of 50% of the amount, 50% of the amount in question, 50% of the amount of debt due to him, due to the borrower, as claimed by secured creditors or determined by the debt recovery tribunal, whichever is less. Stop. There is another proviso to section 18 of the SARFAESI Act, which gives the latitude to the tribunal, appellate tribunal, to reduce the amount to 25%, but only for the reasons to be recorded in writing. Stop. The Learned Counsel for the petitioner has contended that a plain reading of section 18 referred to above would indicate that if any person who should also include a borrower is aggrieved by any order made by DRT under section 17 of the Act, he may prefer an appeal subject to the pre-deposit. In Measures Sunshine Builders and Developers versus HDFC Bank Limited to branch manager and others, 2025 Live Law bracket SC 459. The Supreme Court has held that the expression any order within quotes appearing in section 18 ought to be given some meaningful interpretation. And any and every order that may be passed by DRT ought not to be made subject to such pre-deposit. The Learned Counsel for the petitioner has thus argued that during the pendency of the appeal before the DRT, an interlocutory application was filed by the petitioner for sending the lease deed, sending the sale deed for scientific examination, as he claimed to be in possession of the original sale deed, whereas the respondents 1 and 2 also claimed to be in possession of the original sale deed. The question is whether this prayer was refused, against which this prayer of the petitioner was refused by the DRT, against which order he had preferred an appeal under section 18 of the Act before the appellate tribunal. So the question is whether this order would require pre-deposit of 50%, pre-deposit of 35% of the debt amount. The requirement of making a pre-deposit of 55%, which could be reduced to a minimum of 25% by the appellate tribunal, has been held to be mandatory by the courts. But the petitioner contends that in the present set of facts, fastening the petitioner with the liability of paying, fastening the petitioner with the requirement of making a pre-deposit of 35%, also would it in a way be negating the right of appeal to the petitioner. As the order which has been appealed before the appellate tribunal is only an order with respect to refusal of the request made by the petitioner for sending the sale deed in question for scientific examination, for determining the truth as to who the borrower or the creditor is in possession of the registered sale deed. So, the law in this regard is very clear that since the pre-deposit amount is mandatory, it cannot be made nil by the appellate authority. And the High Court will not normally interfere with such decision of the tribunal unless it is shown that the requirement of pre-deposit is made mechanically by the appellate tribunal and without considering the hardships faced by the borrower. Though there has been no attempt on the part of the petitioner to demonstrate any hardship in making payment of 35% of the debt amount. But the question in this case, the issue in this case is whether the appellant, whether the petitioner could have been asked to make payment of 35% even. 35% of the debt amount, 35% of the debt amount. In the circumstances when the appeal is against an order refusing to send the sale deed in question, which is said to have been mortgaged, for scientific examination. Whether such an order by the DRT would be covered under the expression any order in section 18 of the Act. Let notice be issued to respondents.
Statement for me.
Let notice be issued to the respondents on the steps being taken by the petitioner within a period of 1 week, both modes returnable on 7th of April.
And in the meantime,
2014.
My lord, otherwise
Let it remain.
appeal would become infructuous.
No, we are not saying.
My lord, the appeal would become infructuous.
How it
For
will
weeks,
become infructuous?
4 weeks' time has been given to me to deposit.
In the meantime, till the disposal of this appeal, the DRAT shall not dispose of the appeal preferred by the shall not pass any order directing the appeal, dismissing the appeal as infructuous for the petitioner not having deposited the 35% of the recovered debt amount, which has been directed to pay within 4 weeks. It shall remain only live, that's all. But even under that condition, can it be made zero? We can, subject to what the respondents say, we can reduce it to 25%. That we can do.
My lord, at the time
Can
of
it
hearing,
be reduced? Can it be made negative? Can it be made nil? That's our question. That is not what has been decided in the
Yes,
judgment which has
yes.
been given by you.
because the matter is pending before the Honorable Calcutta High Court, because it has been remanded back.
Anyway, this requires notice. You had made out a case for notice. All right.
Much of it.
Yes.
Item number 11.
Mention.
My lord, dear, my learned friend appears and there's an interim order in my favor, staying the further proceeding. So,
Your lordship may fix some other day for final disposal. Well, I am a-
This is many cases have been adjourned because of the difficulty of the council. Why not today? We have plenty of time.
well, I am appearing for the very first time today. Need some time to complete the instructions.
As jointly prayed for, re-notify, then it goes in October. But then that will take a long time. The company has been liquidated, the
that's it.
company has been taken over,
Track off.
but you're still continuing.
No, but
No, no, the company which has been taken over,
that's it. Liability is.
let this, as jointly prayed for, let this matter be taken up for consideration on 16th of October. All right.
Item 12 and 13.
Mr. Bhuyan.
May please, Lordship, Mr. Puya is on lake in another court and he is not instructed that in this matter, he is going to file the rejoinder. My parent already filed this.
As prayed for on behalf of the petitioners, re-notify. The process is going on, no?
Yes, but
Re-notify on 26th of September.
Highly understood.
Item 14, supplementary list for orders.
May please your expert direction of this honorable
Oh,
court.
yes, he appears.
First time.
Yes.
Lordship,
First
only,
time, what do you want?
yeah, I am representing the respondent number 2 and 3, my lords. Actually,
Yes.
yesterday only I got the soft copy of the same. So Wakalatnama and objections, I just pray for getting me 2 weeks time.
What is your name?
I.S. Majumdar.
Mr. I.S. Mazumdar, who appears on behalf of respondents number 2 and 3, has submitted that he has received you have received instructions or you have received the
No, I have received this one, but hard copy of the Wakalatnama, I have not yet received as of now.
submits that he is yet to receive Wakalatnama on behalf of he is yet to receive Wakalatnama on behalf of respondents number
2 and 3.
2 and
As
3.
well.
He therefore seeks a short reference. Let this matter come up for consideration on
Facebook.
between the 16th of September.
For pronouncement of judgment and order, item number 1 to 5. 1 to 6.
See, all the appeals have been disposed of. So therefore, I'll be reading the concluding paragraphs, about 3-4 paragraphs. All the judgments, it ought not to be lost sight of that these set of cases, the award of grace marks was only for the purposes of increasing the pool of candidates from which recruitment could be made for the post of teachers in secondary schools, subject to such candidates coming in the merit after a due process of selection, but without adding the grace marks. The grace of 5 marks has been given to the candidates who had 60% aggregate but fell short in one paper, and the grace marks have not been counted while computing the merit list of the recruitment. Thus, the grace marks has only enlarged the pool of the eligible candidates so that the adequate numbers could be called for recruitment, that is 2 into the vacancies. Could it then be said that 5 grace marks conferred any undue advantage in the competitive merit list? The answer is obviously no. The persons who got the grace marks were not academically weak, as they had an aggregate of 60%. The grace marks was only given to remove each paper bottleneck. No one, as it appears, stands prejudiced with this. The candidates with higher raw merit would still be selected or have been selected on the basis of ungraced marks. As has already been referred to and held in authoritative judgment of the larger bench in Tej Prakash Pathak, Supra, that where the rules are non-existent or silent, administrative instructions would fill in the gaps. So far as changing the rules of the game midway is concerned, it's again reiterated that this is not with respect to recruitment, but only for the purposes of creating a larger pool for which decision was taken at the appropriate level. True it is that it was not intimated earlier, but no change was made after the results were declared and before the recruitment process was initiated with the issuance of advertisement dated 12/9/2020. This, in our considered view, is no change of the rule of the game midway. Teachers have already been appointed. Education is a matter of public interest. Vacancies in large numbers of schools cannot remain unfulfilled. A large number of schools are dependent on the services of the teachers. Unsettling appointments would create a chaos which would deprive the children of education. It has long been held that equity and public interest weigh against unsettling selections unless illegalities are glaring and prejudicial. In the present case, we have not found any illegality. Here, as merit was determined solely on raw marks, no prejudice can also be said to have been posed to higher merit candidates. We also are of the view that the criticism regarding awarding grace marks of 5 to be arbitrary is misplaced. Grace marks were given only for the eligibility and not for ranking, and therefore in such a situation, the quantum does not distort the merit. For the aforementioned reasons, we do not find ourselves persuaded by the reasonings of the learned single judge, and perforce we set aside the judgment. Impugned and hold the requirement of securing 60% in each paper of TET is a valid and rational prescription, consistent with the object of examination and not inconsistent with the rules. 2, the grant of grace marks to enlarge the pool of eligible candidates without counting such grace mark in merit rank does not prejudice any candidate and it cannot be termed arbitrary. The appointments, number 3, the appointments already made on the basis of raw merit ought not to be unsettled. However, before parting, we need say that the state government must clarify and codify in express terms prospectively the eligibility criteria, whether aggregate or paper-wise, and any policy of moderation/grace marks so that unnecessary litigation is avoided. All these writ appeals stand disposed of accordingly. I've made some correction. I've signed it. No, we have to give it to them. Work for them. You don't say give it to them. Yes.